Magandang araw. Here is our video discussion for module number 14 of BAM 026, and our lesson title is Extinguishment of Obligation Part 5. This is about condonation or remission of debt and confusion or merger of rights. So, dalawa yung modes of extinguishment na pag-uusapan natin sa module na ito. Yung condonation at remission, pareho lang yung ibig sabihin. Yung confusion or merger, pareho lang din yung ibig sabihin. So, huwag kayong mako-confuse sa title ng ito, at ito ay tungkol sa condonation or remission at tungkol sa confusion or merger of rights. Now, our lesson objectives are as follows. At the end of this module, you can define condonation or remission, and you can define confusion or merger of rights. You can also state the kinds of remission and effects of condonation or remission. And thirdly, state the requisites of confusion or merger of rights and its effect in the person of debtor, creditor, and guarantor. So these are new terminologies for you today, but I can assure you that these legal terminologies are not that hard to understand. So let's resume to our productivity tip. You should all be like the players in a professional basketball championship series. They are determined to finish the game strong no matter what. They prepare, plan, and strategize to deliver the greatest game of their lives. So regardless of what happened the last game, they still show up for the next game with the same intensity as if it was the first time. Happy learning. Usually, may 7 games yung isang professional basketball championship series. At kapag natalo ka sa una, pag natalo yung isang koponan sa una, hindi dapat mawawala yung kanilang fighting spirit. Pag natalo ulit sila sa pangalawang beses, may laban pa rin naman. No? So, sila ay pupunta pa rin at talaga naman na ibibigay nila yung kanilang greatest game of their lives. So, to change your life, it is a must for you to give your very best. Okay, let's go to the lesson preview. Again, second period is all about the modes of extinguishment of obligation, and these are as follows. Payment or performance, which we have already discussed, and as well as the loss of the thing due, which is discussed previously in module number 13. So now we are going to discuss condonation or remission of debt and confusion or merger of rights in this particular module. Tapos yung compensation at novation ay i-discuss natin sa susunod na module. Now, we have already tackled nga, like I've said in our previous modules, the relevant provisions on payment or performance and loss of the thing due. So in this module, please prepare to learn the pertinent provisions relative to condonation or remission of debt and confusion or merger of rights. Okay, so you have to pause this for a while and answer the what I know chart. So after the main lesson, ayan, tignan natin etong comics. Marvin, I am renouncing your debt. I hope you will accept my condonation of your debt. Umiiyak tong isa, ang sabi niya, thank you so much, Virna. I lost my job due to the pandemic. This is a big help for me and for my family. So kung makikita nyo, pasabog na tong debt, para tong granada na pasabog na. Pero ang hawak ni Virna ay gunting kung saan puputulin na niya yung mitya nung granada na ito para hindi na sumabog. So ganun yung konsepto ng renunciation ng debt. Renunciation, ibig sabihin, pinapatawad na ng creditor yung debtor sa kanyang pagkakautang. So, ang tawag dito ay renunciation, condonation, remission of debt. Yan, medyo may similarity talaga or synonymous ang mga terminologies na yan. Okay, so pag-usapan natin ang condonation or remission of debt. It is the gratuitous abandonment by the creditor of his right against the debtor. Article 1270, condonation or remission, is essentially gratuitous. It requires the acceptance of the obligor and it may be made expressly or impliedly. Merong mga requisites ang condonation or remission to be valid. Kung mapapansin nyo sa definition ng Article 1270, kailangan pa rin ng acceptance ng obligor. Sino ba si obligor? Si debtor. Kailangan i-accept pa niya yung pagpapatawad ni creditor ng utang para maging valid ang condonation or remission of debt. Bakit kaya? Ano kaya ang logic nito? Hindi ba po pwede na maging masaya na lang siya kasi pinapatawad na siya sa kanyang pagkakautang? Ayan. So tignan natin, merong logic ito kung bakit kailangan pa ng acceptance ng obligor. So let's move on. Pag-usapan muna natin tong requisites. Una, it must be gratuitous. The remission must be costless or free. It must be accepted by the obligor. The parties must have capacity. And it must not be in officious. It means that no one can give more than that which he can give by will or testamentary disposition because the excess will be considered as in officious and the court has the power to reduce it. If made expressly, it must comply with the forms of donation. Okay. So lahat nito parang andali lang, pero bakit parang ang haba ng number 4 na requisites? Ano to? Ang sabi, it must not be in officious. Ano bang ibig sabihin nun? Tignan natin yung comments. Sabi rito, a person cannot condone his debt. Ito yung binabasa ko ha, para lang hindi kayo maligaw. Ito siya, ayan. A person cannot condone his debtor's debt if it will affect the legitime of his heirs. Sabi ng lolo, that is correct. If he did, the court may reduce it insofar as they are inofficious or excessive. Ano ba yung heirs? Ito yung mga tagapagmana. Kung halimbawa ang isang tao ay may mga tagapagmana, hindi niya po pwede na patawarin yung kanyang creditor ng hindi niya pwedeng patawarin yung kanyang debtor ng sobra-sobra kung saan talagang magiging apektado yung mga mamanahin ng kanyang mga tagapagmana. Kung yan ay nagawa na ng creditor na napatawad niya ang utang ng debtor, maaaring i-reduce ng korte yung amount o yung halaga na kanyang pinatawad. Okay. So, ibig sabihin nun, may babayaran pa rin si debtor kay creditor. Yun yung logic ng in officious na salita. Ang sabi rito, no one can give more than that which he can give by will or testamentary disposition. Hindi po pwede na i-condone o ibigay na lamang ng isang tao yung isang bagay na mas malaki pa kesa sa pwede niyang ibigay sa pamamagitan ng testamentary disposition o yung sinasabing huling habilin. Okay, or last will and or testament. Okay. So, ito yung 5 requisites ng condonation or remission. So, pag-usapan natin yung it must be accepted by the obligor. Isa to sa mga requisites ng condonation. Ayan. Sapagkat may mga pagkakataon halimbawa na out of not generosity but out of meanness or rudeness. Okay? At ikasisira ng dignidad ng kanyang kapwa ay pinapatawad na niya ang utang nito. Example, a concrete example. Sige, wag mo na akong bayaran. Total naman, ayun, nilait-lait na niya. Ayun. Total naman, mahirap pa kayo sa daga, yung mga ganyan. So, ikinasakit ng loob ng obligor. Ayan. So, po pwedeng sabihin na obligor na, alam mo, wag mo na akong patawarin sa utang ko sapagkat babayaran kita. Ayan. Pwede rin yun para itatayo niya ang kanyang dignidad na tinatapakan. That is why one of the requisites of the condonation or remission is that it must be accepted by the obligor. Okay? To avoid this kind of scenario. Okay? So, isa lang naman yun sa mga pwedeng dahilan. Actually, marami pa. Ayan. So, next, effect of renunciation of the principal debt to the accessory obligation. Paano nga bang magiging effect ng pagpapatawad ng pautang. Kasi alam nyo, ganito yan. Meron tayong tinatawag na secured loan at unsecured loan. Yung unsecured loan, ito yung umuutang yung debtor kay creditor, pero wala siyang collateral. Meaning to say, wala siyang bahay na nakaprenda, wala siyang sasakyan na nakaprenda, wala siyang alahas na nakaprenda. Basta meron lang isang tao o kaibigan na tumatayong guarantor o surety na magsisigurado na kapag hindi nakabayad si debtor ng kanyang utang, yung guarantor o surety ang bahala. Yun ay tinatawag na contract of guarantee, which is an accessory obligation to the principal obligation na contract of loan. Nagets nyo? Nagets nyo ba? Sana naunawaan ha. So, ibig sabihin, meron tayong contract of loan na isang unsecured loan kung saan naghanap yung debtor ng kanyang kaibigan na magagarantor sa kanya. Yung guarantor na yon, ang pinasok niya na kontrata ay contract of guarantee. So, ngayon, okay. So, papaano kapag yung principal obligation, which is contract of loan, ay ni-renounce na ng creditor? Ano daw ba ang magiging effect ng renunciation ng principal debt sa accessory obligation nung guarantor o nung guarantee? Ayan. So, Article 1273. The renunciation of the principal debt shall extinguish the accessory obligation, but the waiver of the latter shall leave the former in force. Okay. Anong sinasabi rito? Kapag pinatawad na yung principal debt, natural, yung pagiging guarantor ng tao ay may extinguish na rin. Pero kapag ang in-extinguish ay yung accessory obligation o yung pagiging guarantor, hindi nangangahulugan na pati yung principal obligation ay pinatawad na rin. So sana naintindihan nyo to. Okay. So example, isa pang example, Andy owes Brian 1,000 with Phil as guarantor. The principal debt is 1,000. The accessory obligation is the guarantee of Phil. The remission of 1,000 debt shall extinguish the guarantee of Phil. But if only the guarantee is condoned, the principal debt shall remain. So sana naintindihan nyo pa na lalo yung ating pinag-uusapan dahil sa example na ibinigay sa module nito. Let's talk about presumption. The delivery of a private document evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. So it is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or of a third person who owns the thing. Ako, ano ba yung mga pinagsasabi dito sa presumption na to? Ano ba yung pledge? Ayan. Ano ba yung private document evidencing? Okay. So, pag-usapan natin. Okay. So, ang presumption daw, kapag yung papel na nagiging evidence na may pautang o may utang pa si debtor kay creditor ay nasa kamay na ni debtor, ang presumption dito ay as if bayad na siya. Okay ba yan? So again, meron halimbawang papel or promissory note, tama na. Okay? Na pinirmahan si debtor kay creditor. So supposedly, yung promissory note na yun o yung papel na yun, it must be in the possession of the creditor kasi yun yung ebidensya na may utang si debtor sa kanya. Ngayon, kapag yung papel na yun ay hawak na ni debtor, ano ba ang presumption? Ang presumption ay ibig sabihin wala ng obligation si debtor kay creditor. Ang ini-imply na yon ay pwedeng na-renounce o pwede na na-extinguish na. Okay. So ano ba yung pledge naman na tinatawag? So halimbawa, yung pledge kasi ay isang accessory contract. Yung kagaya lang din ng kanina na pinag-usapan natin, kagaya ng guarantee. However, yung guarantee kasi ay para sa unsecured loans. Yung pledge naman, it is usually for secured loans. Ano ba yung secured loans? Ito yung mga loans na may collateral. So yung pledge ay isa sa mga ginagamit na accessory contract para sa isang secured na loan. So example, gusto kong umutang sa'yo. Para pautangin mo ko, kailangan iprenda ko sa'yo yung alahas ko. Okay. So yon, pledge yon. Bakit siya naging pledge? Kasi ang ating object ay movable o yung movable or personal property. Tapos, i-deliver ko sa'yo. Tapos, yun yung mga requisites na, ano? Tapos, ito ay isang accessory obligation or accessory contract to the principal contract which is a contract of loan. Ngayon, kapag kayong alahas na pinrenda ko sa'yo, di ba dapat nasa iyo siya? Okay. Pero biglang nasa akin na yung possession, ano ba ang magiging presumption nun? Ang ibig sabihin nun, yung accessory obligation of pledge has already been remitted. Ibig sabihin, parang ni-renounce na, na-extinguish na yung accessory obligation. Okay. Okay. So pag-usapan naman natin yung confusion or merger of rights. Tignan natin to. Let's talk about confusion or merger of rights. Ito si Jake. Nako-confuse siya. I am the debtor, sabi niya. I am the creditor, sabi din niya. Should I demand payment from me now? Should I pay myself what I owe to myself? Who am I? Now I am really confused. Sabi ng dog, I am lucky to be a dog. So there is a confusion or merger of rights. If one person has a role of being the debtor and creditor of his own self. Paano nangyayari yun na yung tao ay nagiging debtor at the same time nagiging creditor din niya? Okay, pag-usapan natin ito. Ayan. Nagaliitan ko lang ng konti para buo yung ating ano. Okay. Kanino ba nag-umpisa yung kwentuhan? Dito to sa nagja-jogging. Hi, I'm Bill. I bought my running shoes from Mark. I issued a check payable to bearer amounting to 4,500 as payment. I love the color of the shoes, but it is a bit smaller for my feet. Gusto niya daw yung kulay pero medyo maliit. Binili niya kay Mark. Tapos inisyuhan niya ng cheque si Mark. Ayan. Ito na si Mark. Hi, my name is Mark. I used the check issued by Bill to buy me some books from Chris. This is going to be a very busy week. So yung ipinambayad pala ni Bill kay Mark ay siya ding pinambayad ni Mark kay Chris. Kuha niya yan? Okay. Ito naman si Chris. Hi, I'm Chris. I heard Bill has a really cool shoes that I really like. It is a limited edition and I'm willing to pay the full price. I will use the check Mark gave me to pay for the shoes and I'm so excited. So itong si Chris, nabalitaan niya si Bill may magandang shoes na ang nagiging problema nga ni Bill, maliit naman sa kanya. So itong si Chris, willing siyang bilhin yung sapatos na yon dahil daw limited edition yon, handa niyang bilhin kahit pa medyo nagamit na. Okay. Ayan. So, problema, ang ibabayad niya, yung ibinayad ni Mark sa kanya, na ibinayad lang din ni Bill kay Mark. Ayan. So, ang ending nito, ayan, sabi ng aso, if Chris will use the check issued by Bill to pay Bill, then Bill will become the debtor and creditor of himself. I know this. It's called confusion or merger of rights. Galing nung aso. So sa madaling salita, Finally, na kaninong kamay ba yung cheque? O, di ba? Mapupunta kay Bill. Kasi ibabayad na rin yun ni Chris kay Bill para sa sapatos. Ngayon, ang ending, bumalik tayo rito kay, kay Jake. Imagine niyo ito si Bill. Di ba? Hawak ni cheque, isa rin nag-issue nun. So sabi niya, I am the debtor, I am the creditor. Should I demand payment from me now? So imagine niyo, ipapa-encash pa ba niya yung cheque? Pera din naman niya yung kukuhanin niya doon. Okay, para lang din i-deposito pagkatapos. So sa madaling salita, that is what we call confusion or merger of rights. Okay, so sana naintindihan niyo yung concept ng confusion or merger of rights. According to Sanchez-Roman, confusion or merger is the meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So it is a mode of extinguishing obligation because if a debtor is his own creditor, it will be hilarious if he will enforce the debt against himself, just like the illustration about Jake. So merger in the person of the principal debtor and creditor extinguishes the obligation. Hence, the accessory obligation of guarantee is also extinguished in accordance with the principle that the accessory follows the principal. Okay. So consequently, merger which takes place in the person of the guarantor while it extinguishes the guarantee leaves the principal obligation in force. Okay. So, ngayon, pag-usapan natin yung confusion in a joint obligation. Sana naalala niyo pa kung ano yung joint obligation. Ito yung obligation kung saan pwedeng maraming debtor, pwedeng maraming creditors, di ba? Ayan. So, Article 1277, confusion does not extinguish a joint obligation except as regards to the share corresponding to the creditor or debtor in whom the two characters concur. Pag-usapan natin mabuti. Example, si A at B ay jointly liable to X in the amount of 5,000 evidenced by a negotiable promissory note. B endorsed the note to E, and E endorsed the note to A. In this case, A's share in the obligation is extinguished because of confusion in his person. A will become the new creditor of B in the amount of 2,500. Okay. So, tignan natin itong mabuti ha. Bago kayo malito, feeling ko, may correction dito. Itong si D, dapat siya si X. Ito, si D. Ayan. So, ulitin natin itong kwento. Si A at si B ay debtors ni X sa halagang 5,000. Ngayon, meron silang pinirmahan na negotiable promissory note. Ayan. So, yung promissory note na yon ay in-endorse ni X kay E. Pag sinabi natin in-endorse, pinirmahan yon ni X na para bang ipinapasa na niya yung note na yon kay E. So sa madaling salita, si E na yung magiging creditor ni A at ni B. Ngayon, itong si E, in-endorse yung note kay A. Okay. So ibig sabihin, hawak na ni A yung promissory note. Ngayon, in this case, dahil si A ay isa sa mga pumirma nung promissory note na yon na bilang debtor, and at the same time ngayon naman ay creditor na siya, magkakaroon na ng extinguishment because of confusion in his person. So sa makatwid, dahil si A na yung may karapatan na maningil ng 5,000, dahil in-endorse na yun sa kanya ni E, okay, sisingilin pa ba niya yung sarili niya? Again, dahil in-endorse na ni E yung note kay A, di ba siya na yung bagong creditor? Ang problema, si A, siya din yung debtor sa promissory note na yon. So, nagkaroon na ng merger of rights or confusion. Kung siya yung creditor, dahil nga sa effect na in-endorse yun sa kanya ni E, sisingilin pa ba niya yung sarili niya? So, syempre, hindi na. Pero si B, pwede pa niyang singilin. That's why ang sabi rito sa huli, A will become the new creditor of B in the amount of 2,500. So sana naintindihan niyo yung example na ito. Papaano naman yung confusion sa isang solidary obligation? So, merger in the person of one of the solidary debtors shall extinguish the entire obligation because it is also a merger in the other solidary debtors. So, that is Article 1250. So, ma-extinguish yung entire obligation. Kung mapapansin nyo, anong pagkakaiba ng dalawa? Sa joint obligation, yung confusion or merger, hindi nag-result ng extinguishment ng entire obligation. Dito, si A, pwede pa rin niyang singilin si B. However, sa solidary obligation, kapag may confusion, the entire obligation is extinguished. Okay, so this is the end of our discussion for this particular module. Please answer activity 3 and so on. And please finish this module. See you all next discussion.